Good afternoon, everyone. Let me open the session of the Committee Against Torture, number 1267. As you all know, we have consideration of the report from the United States, and today we're going to hear the replies of the States Party to the Convention. Just to brief you about the procedure, first we will listen to the States Party's delegation, and we will hear the responses to the questions of the committee put forward yesterday. And the delegation will have 90 minutes, 90, to reply to the questions. Then I will have to pass the floor back to the committee members, starting with two rapporteurs, and then with the committee members who will wish to take the floor. So, the floor is yours, Ambassador, and thanks again for joining us today here.
Thank you, Mr. Chair. Members of the committee, on behalf of the U.S. delegation, we thank you all for your important and thought-provoking questions. Particular thanks goes to Rapporteurs Mr. Bruni and Mr. Medvig. We look forward to having a useful dialogue and value your input on how we can make further progress. I note at the outset that a number of members of the committee have asked for extensive and detailed data. Our team has done its best overnight so that we can provide you with as much as we can. Other information was not readily available. To help the committee understand how we are structuring this response, I wanted to provide a bit of a roadmap. In order to address as many of your questions as possible in our allotted time, we have largely organized our presentation by agency. Following me, my Department of State colleagues will begin our response. General Gross will then speak on behalf of the Department of Defense, and I will follow General Gross. After that, colleagues from the Department of Justice, Department of Homeland Security, and the states of Rhode Island and Mississippi will answer additional questions. Assistant Secretary Tom Malinowski will then conclude this portion of our response. Please do not take the brevity of our responses as minimizing the importance of these issues. With that, I will turn it over to Acting Legal Advisor Mary McLeod to start our responses. Thank you.
Thank you, Mr. Ambassador. Mr. Bruni and Mr. Gaillet, you raised questions about non-refoulement and the use of diplomatic assurances. First, as a matter of fundamental policy and practice, the United States does not transfer any individual, whether located in U.S. territory or not, to a foreign country if it is more likely than not that the person would be tortured. This principle is woven thoroughly into U.S. policy and practice in a number of ways, including Section 1242 of the Foreign Affairs Policy and Restructuring Act, where it is specifically stated, and in Executive Order 13491, which required the formation of a special task force on transfer policy to study and evaluate the practices of transferring individuals to other nations in order to ensure consistency with all applicable laws and U.S. policies pertaining to treatment. The task force made a number of policy recommendations to ensure that persons are not transferred to face torture when the United States moves or facilitates the movement of a person from one country to another, or from U.S. custody to the custody of another country. The President accepted the report. If the United States determines, after taking into account all available information, that it is more likely than not that a person will be tortured, the United States will not make the transfer. The United States considers a range of factors in determining if it is more likely than not that a person will be tortured, and the issuance of diplomatic assurances and the reliability of those assurances is only one such factor. Other factors considered include any allegations by the person of prior or potential mistreatment by the receiving government, the receiving country's human rights record, and whether similarly situated persons have been tortured. There have been cases where the United States has declined to return individuals because the United States was not satisfied that even with assurances, the transfer would be consistent with its non-refoulement obligations, policies, or practices. For example, the United States has long maintained its position that it would not repatriate Uyghurs to China from Guantanamo due to our humane treatment policies. In some cases, we seek assurances as a prudential matter, not because they are necessary for the transfer to be consistent with the non-refoulement principle, but rather to reduce further any meaningful risk of mistreatment. Likewise, in the context of armed conflict, the U.S. practice has been to seek humane treatment assurances. To answer your specific question, Mr. Bruni, we have received humane treatment assurances from every country to which we have transferred a detainee from Guantanamo during this administration. Mr. Gaillet, you asked what corrective measures we would be able to apply if a country did not abide by its diplomatic assurances, in view of the fact that the transferred person would be in the hands of the receiving state. With respect to law of war detainees and in other contexts involving continued detention where appropriate, the United States requires assurances of private access on minimal notice for post-transfer monitoring by credible independent organizations or U.S. government officials. If that monitoring reveals mistreatment or other credible information of mistreatment comes to our attention, we may suspend future transfers. I'll now turn to your question, Mr. Bruni, pertaining to the United States understanding that mental pain or suffering refers to prolonged mental harm. When the United States was considering becoming a state party to the convention, there was some concern that the convention's definition could not satisfy the constitutional requirement of precision in defining criminal offenses with respect to mental pain and suffering. We conditioned our ratification upon an understanding that mental pain or suffering refers to prolonged mental harm to provide the requisite clarity and specificity for purposes of domestic law. With regard to your question, Ms. Belmire, related to the International Criminal Court, the United States has signed agreements with more than 100 states that apply to United States persons. In general, states concluding the agreements agree to surrender or transfer such persons to the International Criminal Court only with the consent of the state concerned. To date, there have not been any requests for such consent under these agreements. For its part, the United States is fully committed to investigating and prosecuting, where appropriate, acts that amount to war crimes, crimes against humanity, and genocide alleged to have been committed by its officials, employees, military personnel, or other nationals. The agreements contain language specifically underscoring this intention and reaffirming the importance of bringing to justice those who commit such crimes, and this would include any such crimes that are covered by the Convention. At this point, I'll turn to questions related to enhanced interrogation techniques. As ordered by President Obama, the former detention and interrogation program is over and will not be reinitiated. This is reflected in our laws. The Detainee Treatment Act of 2005 prohibits cruel, inhuman, or degrading treatment or punishment at all times and in all places, and CIA Director John Brennan has made clear that no agency, officer, or contractor will participate in any interrogation activity inconsistent with the Detainee Treatment Act or the Army Field Manual. My colleague, Brigadier General Gross, will speak more about the Army Field Manual shortly. President Obama's Executive Order 13491 also required the CIA to close as expeditiously as possible any detention facilities that it operated and prohibited it from operating any such detention facility in the future. The CIA is in full compliance with the requirements of that executive order and does not maintain detention facilities. At this point, I would like to turn this over to my colleague from the State Department, Catherine Amirfar.
Thank you. In the Legal Advisor's Office at the Department of State, it is a privilege to be here on behalf of the United States today, and I thank the committee for its thoughtful comments and questions. Messrs. Bruni and Modbig, I will address the questions you posed with respect to the geographic scope of the application of the Convention. So let me start by saying that torture is absolutely prohibited at all times, in all places, no matter what the circumstances. Likewise, cruel, inhuman, or degrading treatment or punishment is absolutely prohibited at all times and in all places. And these are legal prohibitions based on U.S. domestic law, treaties, and customary international law. For example, the prohibition against torture is customary international law binding on all nations everywhere at all times. Articles 2 and 16 of this convention require prevention of both torture and cruel, inhuman, or degrading treatment or punishment in territory under U.S. jurisdiction. Under the DTA, or the Detainee Treatment Act of 2005, takes it even further. No individual in the custody or under the physical control of the U.S. government, regardless of nationality or physical location, shall be subject to cruel, inhuman, or degrading treatment or punishment. Under the DTA, the prohibitions apply at all times and in all places, not just to territory under U.S. jurisdiction. In the context of armed conflict, the Geneva Conventions prohibit torture and cruel treatment as well. President Obama issued Executive Order 13491 to ensure humane treatment in compliance with the treaty obligations of the United States, including this convention and the Geneva Conventions. Any individual detained in any armed conflict who's in the custody or under the effective control of the United States or detained within a facility owned, operated, or controlled by the United States in all circumstances must be treated humanely and must not be tortured or subjected to cruel, inhuman, or degrading treatment or punishment. Taken together, these make clear that these prohibitions are categorical and unequivocal. They bind the United States and its officials at all times, everywhere. There exists the separate question under the Convention of the geographic reach of the Articles, specifically referring to territory under a state's jurisdiction. Since its last presentation, the United States has carefully reviewed the extent to which such obligations under the Convention apply beyond the sovereign territory of the state's parties. The United States understands that where the text of the Convention provides that obligations apply to a state party, quote, in any territory under its jurisdiction, end quote, such obligations extend to all places that the state party controls as a government authority. We believe this is the proper interpretation of the Convention. It's consistent with the position taken by both the U.S. executive branch during the ratification of the Convention and by the U.S. Senate in considering whether to provide advice and consent to ratify the Convention. This language clearly covers the sovereign territory of the United States. In addition, we believe that it covers other places the United States controls as a governmental authority. We've concluded the United States currently exercises such control at the U.S. Naval Station at Guantanamo Bay, Cuba, and overall proceedings conducted there, and with respect to U.S. registered ships and aircraft. I should note that with respect to the obligation in Article 16 to prevent cruel, inhuman, or degrading treatment or punishment, that provision also explicitly extends to territory under a state's jurisdiction. As this committee is aware, the United States submitted a reservation with respect to that provision to ensure that existing U.S. constitutional standards would satisfy U.S. obligations under that article. Let me be clear that this reservation to Article 16 does not introduce any limitation on the geographic applicability of that article. The obligations in Article 16 apply beyond the sovereign territory of the United States to any territory under its jurisdiction in line with the interpretation I have just outlined. Now, with respect to the application of the Convention at Guantanamo, in our last presentation to the committee, the United States stated that Article 15 of the Convention is a treaty obligation and that the United States had to abide by that obligation in the Combatant Status Review Tribunals, also known as the CSRTs, and the Administrative Review Boards, also known as ARBs, which were administrative procedures established to review the status of law of war detainees at Guantanamo Bay. CSRTs and ARBs are no longer conducted, but the United States reaffirms its obligation to abide by Article 15 in the periodic review board processes, which is a current discretionary administrative process for the review of law of war detainees at Guantanamo, as well as in the military commissions. In that regard, the Military Commissions Act of 2009 mandates, and I quote, "No statement obtained by the use of torture or cruel, inhuman, or degrading treatment shall be admissible in a military commission, except against a person accused of torture or such treatment as evidence that the statement was made." Implementing this exclusionary rule in the context of reviewing or prosecuting individuals detained in armed conflict complements and reinforces the prohibition on torture and the fair trial guarantees mandated by the law of armed conflict. With that, let me turn back to my colleague, Ms. McLeod, to address one further point.
Mr. Modvik, I now turn to your question about the applicability of the Convention during armed conflict. In terms of our international law obligations, during situations of armed conflict, the law of armed conflict is the lex specialis, and as such, is the controlling body of law with regard to the conduct of hostilities and the protection of war victims. Moreover, as the United States has already recognized, a time of war does not suspend the operation of the Convention Against Torture, which continues to apply, even when a state is engaged in armed conflict. Article 2.2 of the Convention specifically provides that neither a state of war nor a threat of war may be invoked as a justification for torture. In addition, the law of armed conflict and the Convention contain many provisions that complement one another and are in many respects mutually reinforcing. For example, the obligations to prevent torture and cruel, inhuman, or degrading treatment or punishment in the Convention remain applicable in times of armed conflict and are reinforced by complementary prohibitions in the law of armed conflict. Whether you are looking at human rights law or the law of armed conflict, the prohibition against torture and cruel treatment is categorical. There are no gaps. Although Article 14 of the Convention contemplates an enforceable right to fair and adequate compensation for victims of torture, it would be anomalous under the law of war to provide individuals detained as enemy belligerents with a judicially enforceable individual right to a claim for monetary compensation against the detaining power for alleged unlawful conduct. The Geneva Conventions contemplate that claims related to the treatment of POWs and protected persons are to be resolved on a state-to-state level, and war reparations claims have traditionally been, and as a matter of customary international law are, the subject of government-to-government negotiations as opposed to private lawsuits. In closing, there can be no question that the clear position of the United States is that torture and cruel, inhuman, and degrading treatment or punishment are legally prohibited everywhere and at all times. There can also be no question that these prohibitions continue to apply even when the United States is engaged in armed conflict. These prohibitions exist under domestic and international law, including human rights law and the law of armed conflict. The United States remains dedicated to enforcing these prohibitions to ensure that there are no gaps, that there are no loopholes, in order to fulfill a primary purpose of the Convention, to recognize the inherent dignity of persons and right to be free from torture and cruel, inhuman, and degrading treatment or punishment. And now let me give the floor to Brigadier General Richard Gross.
Thank you. Mr. Chairperson, distinguished members of the committee, I am Brigadier General Rich Gross, and I am here on behalf of the Department of Defense. I am honored to address the committee today regarding U.S. military operations and policy. At the outset, I would like to reaffirm the Department of Defense's commitment to the United States' clear position that torture and cruel, inhuman, or degrading treatment or punishment are categorically prohibited under domestic and international law everywhere at all times. Now, let me start by addressing the questions from Special Rapporteur Bruni about President Obama's commitment to close the detention facility at Guantanamo Bay and the current population there. As you noted, sir, President Obama has repeatedly reaffirmed his commitment to close the detention facility, and in his May 2013 speech at the National Defense University, he outlined a series of steps to reach that goal. Since then, 18 detainees have been transferred from Guantanamo. The vast majority of these transfers were a result of internal administrative review procedures established to ensure we detain only those who continue to represent a significant threat to the United States. The United States is currently holding 148 individuals at Guantanamo under law of war authority. Of those, 79 detainees are currently designated for transfer, subject to appropriate security and humane treatment measures. 33 detainees have been designated for potential prosecution, either in federal court or by military commission, and 36 detainees are designated for continued law of war detention and will be periodically reviewed. Now, Ms. Belmere, you ask about the periodic review of detainees. The Periodic Review Board, or PRB, process mandated by President Obama began in October of 2013. This process is a discretionary, administrative, interagency process intended to assist the executive branch in making informed decisions as to whether detainees held at Guantanamo Bay should remain in detention under the law of war. On November 5th, the United States completed the first repatriation of a detainee designated for transfer by the PRB. And Ms. Belmar, to address your questions regarding the legal status of detainees at Guantanamo, I would like to note that these detainees continue to be detained lawfully, both as a matter of international law and U.S. domestic policy. As a matter of international law, the United States is engaged in an armed conflict with al-Qaeda, the Taliban, and associated forces. As part of this conflict, the United States has captured and detained enemy belligerents and is permitted under the law of war to hold them until the end of hostilities. All U.S. military detention operations conducted in connection with armed conflict, including at Guantanamo Bay, are carried out in accordance with international humanitarian law, including Common Article 3 of the Geneva Conventions and all applicable international and domestic laws, including the Convention Against Torture. Now, Special Rapporteurs Bruni and Modvig, you ask about specific fair trial guarantees to Gitmo detainees, and in particular, Article 15 protections within the military commissions. All current military commission proceedings at Guantanamo incorporate fundamental procedural guarantees that meet or exceed the fair trial safeguards required by Common Article 3 to the Geneva Conventions and other applicable law. These fundamental procedural guarantees include the presumption of innocence, the right to counsel, including specially trained counsel in capital cases, the right to discovery of evidence, and the right to appeal conviction, ultimately to the U.S. federal courts. In compliance with Article 15, the Military Commissions Act expressly forbids the introduction of a statement obtained by the use of torture or by cruel, inhuman, or degrading treatment, except against a person accused of torture or such treatment as evidence that the statement was made. Now, Mr. Modvig, regarding your question about the classification of certain information in military commissions, we must balance the need to comply with U.S. law and regulations regarding the protection of classified national security information with the United States' strong interest in ensuring the detainees meaningful access to counsel, including the ability of detainee counsel to access relevant classified information. The United States respects the critical role of detainee counsel in these proceedings and will continue to make every reasonable effort to ensure that counsel can communicate effectively and meaningfully with their clients. Now, many of you ask about the U.S. Army Field Manual on interrogations. And Mr. Zhang, sir, you asked for a copy of that manual. The manual is publicly available in its entirety online, and we've provided you with the link at your chairs. The interrogation techniques or guidelines in the Army Field Manual are consistent with U.S. domestic and international legal obligations, and the techniques are binding on the U.S. military as well as all federal government agencies, including intelligence agencies and the High Value Interrogation Group, or HIG. This applies to all individuals in U.S. custody or under U.S. effective control in any armed conflict. The manual explicitly prohibits threats, coercions, and physical abuse. Nothing in the Army Field Manual, to include Appendix M, authorizes or condones the use of sleep manipulation or sensory deprivation. For example, Mr. Bruni, you mentioned the language in Appendix M that states that the use of separation must not preclude the detainee getting 4 hours of continuous sleep every 24 hours, and questioned whether that would be adequate over a 30-day period. First, this standard must, of course, be applied consistently with all applicable legal, regulatory, and policy principles and guidelines, which provide that all prisoners and detainees, regardless of status, will be treated humanely. The 4-hour standard is not a daily limit, but rather a minimum standard. It is certainly not intended to mandate, for example, 30 days of separation with only 4 hours of sleep per day, nor would it allow 40 continuous hours of interrogation with only 4 hours of sleep on either end. As the manual states, in attempting to determine if a contemplated technique or approach should be considered prohibited, Consider whether, if the proposed technique were used by the enemy against one of your fellow soldiers, you would believe your soldier had been abused. And I personally use that particular phrase with folks in determining whether the technique they want to use is lawful. Now, Mr. Bruni, you ask about the registration of detainees. In every armed conflict, the United States has taken seriously its obligations under domestic and international law to ensure humane treatment of detainees. Under standard U.S. military procedures, each individual detained by U.S. forces for more than a temporary period is assigned an internment serial number, or ISN, which begins a formal process of oversight and record keeping. Every ISN is reported to the International Committee of the Red Cross, or ICRC, and the ICRC is given access to these individuals as well as to all internment locations. Every person who is released from detention is afforded an exit interview with the ICRC, wherein he or she is given the opportunity to raise any concerns or allegations of mistreatment. In addition, by executive order, all departments and agencies must provide the ICRC access to detainees in a manner consistent with Department of Defense regulations and practice. Mr. Modvig, you also ask about independent medical examinations and issues of medical ethics with regard to detainees. Detainees at Guantanamo are provided with high-quality medical care, comparable to that which our own service personnel receive while serving there. U.S. practice is consistent with principle number 2 of the non-binding principles of medical ethics. DoD physicians and healthcare personnel charged with providing care to detainees take that responsibility very seriously. Military physicians, psychologists, and other healthcare personnel are held to the highest standards of ethical care and at no time have been released of their ethical obligations. Permitting non-military medical examinations of detainees would undermine the effectiveness of healthcare delivery. In addition, the availability of outside medical examinations could encourage detainees to refuse the care of the Guantanamo medical staff in an attempt to attain such examinations and to get alternate treatment plans. Nevertheless, the Department of Defense has allowed independent non-military medical examinations of Guantanamo detainees on a limited case-by-case basis where circumstances warrant such an exception. Now, Mr. Bruni and Mr. Modvig, you ask about the enteral feeding of detainees at Guantanamo. Enteral feeding is used as a last resort, where necessary, to address significant health issues caused by malnutrition and/or dehydration. It is the policy of the United States to support the preservation of life by appropriate clinical means in a humane manner and in accordance with all applicable laws. The Department of Defense has established clinically appropriate procedures to address the medical care and treatment of individual detainees experiencing the adverse health effects of clinically significant weight loss. These procedures are administered in accordance with all applicable domestic and international law pertaining to humane treatment. My colleague from the Department of Justice will address Mr. Bruni's specific question about the ongoing litigation over these procedures. Now, Mr. Modvig, you asked for additional information regarding investigations and prosecutions for the alleged mistreatment of detainees. The U.S. military is and always has been required to investigate every credible allegation of mistreatment by U.S. forces in order to determine the facts, including identifying those responsible for any violation of law, policy, or procedures, no matter how senior that individual may be. The U.S. military has a robust judicial system and other administrative mechanisms designed to ensure that personnel adhere to the law and policy associated with military operations and detention. Pursuant to these mechanisms, the Department has conducted thousands of investigations since 2001 and prosecuted or disciplined hundreds of service members for mistreatment of detainees and other misconduct. For example, more than 70 investigations in Afghanistan resulted in full courts-martial. Close to 200 resulted in either non-judicial punishment or adverse administrative action, and many more were investigated and resulted in action at a lower level. Now, Mr. Modvig and Ms. Pradhan-Mala, you ask about measures to prevent sexual violence and assault in the military. Eliminating sexual assault from the military is one of our absolute top priorities. Through continuous assessment and improvement, we seek to improve our response and prevention programs, and it is one of the Secretary's highest priorities. Within the past couple of years, the Department has implemented monumental reform efforts in this area. The Secretary of Defense has directed a range of initiatives designed to strengthen new and existing programs addressing areas including commander accountability, oversight, investigative quality, pretrial investigations, command climate, victim advocacy, and victim support and safety. In addition to physical and mental health care for survivors who remain on active duty, survivors who transition out of military service are offered physical and mental health care through the Department of Veterans Affairs, the VA, the Veterans Health Administration Mental Health Services, Veterans Centers, and other resources. The VA provides free, confidential treatment for mental and physical health conditions related to sexual trauma, regardless of service-connected disability ratings. At this time, I will now return the floor to my colleague, the Ambassador.
Thank you, General. Members of the committee, I will address questions raised by Mr. Bruni and Mr. Modvig regarding the potential visit to the United States by Special Rapporteur on Torture and Other Cruel, Inhuman, and Degrading Treatment or Punishment, Juan Mendez. As a starting point, we want to be clear that the United States fully supports Special Rapporteur Mendez and his mandate. We appreciate his diligence in examining situations involving torture and cruel, inhuman, or degrading treatment or punishment around the world. Accordingly, we are open to a country visit to the United States by Special Rapporteur Mendez. To the question regarding a visit to detention facilities in the United States, we hereby confirm our willingness to facilitate such a visit. We have communicated the same to Mr. Mendez. To the question regarding Guantanamo specifically, as we have made clear to Mr. Mendez, we would welcome his visit under the terms previously conveyed to him. Security concerns dictate limitations on detainees' ability to communicate with others during wartime. Therefore, Mr. Mendez would have the same access as is granted to members of our own Congress and civil society. Private access to detainees is only granted, however, first to the International Committee on the Red Cross as contemplated by the Geneva Conventions, and two, to Detainee Council. Both Detainee Council and ICRC have special roles and responsibilities. Both, furthermore, are bound by duties of confidentiality. I also wanted to thank Mr. Bruni for mentioning the UN Voluntary Fund for Victims of Torture. As many of you know, the United States has had a long-standing commitment to the fund and to its mission. It is a mission which has important links to the goals and purposes of this committee. And now I will turn it over to Robin Jacobson, Associate Deputy Attorney General for the Department of Justice.
Thank you, Ambassador. Distinguished members of the committee, my name is Robin Jacobson, and I am an Associate Deputy Attorney General at the U.S. Department of Justice. I am honored to appear here today on this subject of such importance to the Department of Justice, and to have the opportunity to respond to your questions about individual redress under Article 14, the availability of habeas corpus to persons detained by the United States, certain medical issues pertaining to detainees, registration of detainees, watch lists, and rehabilitation of torture victims. To begin with Article 14, outside the context of the law of armed conflict, U.S. law provides a wide range of civil remedies for seeking redress in cases of torture. These include injunctions, compensatory damages, punitive damages, and declaratory relief. In addition, the U.S. Congress has authorized the federal government to bring civil actions to enjoin acts or patterns of conduct that violate constitutional rights, including those that would amount to torture. At the federal level, the principal avenues of individual redress are administrative tort claims and civil litigation. Common law tort actions for assault, battery, wrongful death, civil actions for violations of federally protected civil rights, suits based on federal constitutional rights. On the state level, all of our states provide for civil tort suits to be brought against state officials, and many permit damages for violations of state constitutional rights. With respect to prisoners in particular, Mr. Modvi, Ms. Pradamala, and Mr. Chairperson, you all expressed concern about the Prison Litigation Reform Act, and in particular the requirement that there be an underlying physical injury in order to qualify for compensation for emotional distress. The Act was broadened in 2013 to allow a showing of the commission of a sexual act as an alternative to physical injury to establish eligibility for compensation for emotional distress. The Act does, as you noted, require inmates to pursue and exhaust administrative remedies before bringing suit in federal court. That requirement provides correctional agencies both an opportunity and an encouragement to resolve the issues themselves. If and when a case must go to court, it then ensures that there will be a full record available on which to evaluate those claims. Importantly, the Act does not preclude incarcerated persons from seeking other legally available relief, apart from compensatory damages, for mental or emotional injury from unconstitutional conditions of confinement. Now, apart from the limitations imposed by that Act, prisoners in federal or state prisons claiming that they have been tortured may seek redress against state and local officials in a civil suit for violations of fundamental rights pursuant to 42 U.S. Code Section 1983, a federal statute. They may obtain monetary damages and may seek injunctions to require prison officials to correct conditions that violate the Constitution. Mr. Morvig, you asked questions about the reach of the right to habeas corpus for persons detained by the United States. Under the U.S. Constitution, and absent exceptional circumstances, all persons in the United States have the right to seek habeas corpus review, challenging the lawfulness of their detention. With respect to the reach of the constitutional right to habeas corpus outside the sovereign territory of the United States, our Supreme Court has identified factors to be considered, including the citizenship and status of the detainee, the adequacy of the process through which that status determination was made, the nature of the apprehension and of the sites of apprehension as well as the detention, and the practical obstacles that are inherent in resolving a habeas claim in those circumstances. The right to bring habeas proceedings has been held by the courts to reach extraterritorially to the detainees held by the military at Guantanamo, as well as to U.S. citizens detained by U.S. military authorities overseas in Iraq. The U.S. respects the fundamental importance of the role of detainees' counsel in all such proceedings and makes efforts to ensure that counsel can represent detainees in an effective and meaningful manner. For habeas cases challenging military detention at Guantanamo, detainees can request a court-appointed lawyer to serve free of charge. And in addition, hundreds of private attorneys have volunteered their experience and their time to provide that legal representation. Mr. Bruni, General Gross has already addressed many of the questions you asked about enteral feeding, but you also asked for an update on the status of litigation involving Guantanamo detainees, and I'm happy to provide that. As you noted, in early October, a federal district judge in Washington, D.C., conducted an evidentiary hearing addressing a legal challenge brought by a detainee, Abu Diab, to the enteral feeding policies at Guantanamo. That followed a lengthy evidentiary discovery period, and it included expert testimony submitted by the detainee's counsel. Just last week, the court rejected the detainee's challenge and denied his motion to enjoin the enteral feeding protocols. The court held that the record established that Joint Task Force Guantanamo had provided that detainee and the detainees subject to these protocols with appropriate medical care, was not deliberately indifferent to his medical needs, and had not deliberately caused him pain and suffering. The detainee has formally indicated that he will appeal that ruling. In accordance with the judge's order in that case, classified videotapes that relate to those feedings have been produced to Mr. Diab's attorneys and submitted to the court under seal. On October 3rd, the court ordered also that the videos be publicly disclosed with certain information redacted. Last week, the court granted the government's request to stay that order until December 2nd, pending a decision by the United States whether to appeal. And just yesterday, a different federal judge denied another request by a different detainee to enjoin the Guantanamo enteral feeding policy as to him, finding no deliberate indifference to the detainee's medical needs, and citing the reasoning by the federal judge in the Diab case, which we just talked about. Mr. Motvig, you also asked about independent medical examinations, and General Gross has addressed that issue with respect to Guantanamo detainees, and he explained the rationale for the limitations in that policy. The Federal Bureau of Prisons is charged by statute with providing medical care for inmates, and it does so with its own staff and with officers from the U.S. Public Health Service. The physicians who treat inmates follow all relevant medical and ethical requirements and take those very seriously. And outside medical examinations and treatment are arranged by the Bureau of Prisons under contract when medically indicated. Mr. Bruni, you asked about registration for detainees, and General Gross has addressed that issue with respect to detainees held by the military. Although there is no unified national policy governing registry of all persons in detention in the United States, relevant federal, state, and local authorities maintain appropriate records on persons they detain. The U.S. and state constitutions, as well as other laws, provide comprehensive safeguards to ensure that those in detention are protected and provided due process. In the criminal context, all persons are booked when taken into custody, and such bookings, which generally include name, description, charges, and emergency contact information, are public information. Moreover, the requirement for a prompt public court appearance provides further protection. Mr. Delmar, you asked about watch listing, which we understood to be a reference to the U.S. no-fly list. The U.S. government is actively reviewing and revising the existing redress procedures regarding the no-fly list. In so doing, we are attempting to increase transparency for certain individuals denied boarding who believe they're on the no-fly list and have submitted inquiries to the Department of Homeland Security. And we're doing so consistent with the protection of national and transportation security and classified and other sensitive information. Finally, Mr. Motvig, we appreciate your recognition of the efforts of the United States to date to help rehabilitate victims of torture. The Torture Victims Relief Act, originally enacted in 1998, authorizes funding for a number of programs that provide rehabilitation services, including funding for the Department of Health and Human Services and the U.S. Agency for International Development to support treatment centers and programs in and outside the U.S., respectively. The Department of Health and Human Services Agency for Children and Families provides funding to 30 torture treatment centers located in 19 of our 50 states. It funds research for survivors of torture and related trauma. And the USAID Victims of Torture Fund provides funding for rehabilitation services for torture victims located outside the United States and helps fund research on torture treatment through Johns Hopkins University. Now my colleague, Mr. Bidkauer, will address some of your additional questions. Thank you.
Good afternoon. Once again, my name is David Bidkauer, and I am a Deputy Assistant Attorney General from the Justice Department's Criminal Division. Mr. Motvig and Mr. Zhang, you both asked about training in lawful interrogation methods and internal reporting requirements and internal reporting mechanisms as well. We believe that the training described in our periodic report has been successful in preventing mistreatment during interrogation. The FBI continually trains its personnel on adherence to the Constitution and laws of the United States, including the prohibition against torture, and to promote the humane treatment of any detainee with whom it is involved. This is the case whether the detainee is in FBI custody or the custody of another agency or country. With regard to internal reporting mechanisms, the FBI has in place a range of internal controls and oversight mechanisms that are intended to prevent, detect, and address any violations of law or policy. I can also offer the following additional information from the Bureau of Prisons. At the Federal Bureau of Prisons, allegations of mistreatment of inmates are investigated by the BOP's Office of Internal Affairs and/or the Department of Justice's Office of Inspector General. All staff members are subject to discipline, including suspensions, demotions, and removals for mistreatment of inmates. For cases closed during the past year, there were 26 subjects with a sustained physical abuse allegation. If warranted, staff members can be referred for criminal prosecution as well, as in an example that I will cite in a moment. Mr. Bruni, you asked about interrogation techniques employed by the High Value Detainee Interrogation Group, or HIG. The HIG was established to improve our ability to interrogate the most dangerous terrorists by bringing together personnel from the FBI, the CIA, and the Department of Defense. HIG personnel are bound to comply with the legal and policy limitations of the HIG itself, as well as of their home agencies. Thus, interrogations conducted or supported by the HIG, like all interrogations conducted by personnel from its constituent agencies, are conducted consistent with the provisions of Executive Order 13491 and with United States domestic and international law, including the Convention Against Torture. Mr. Bruni, you also asked what measures existed to respond to the use of enhanced interrogation techniques if they are still practiced. Enhanced interrogation techniques are no longer practiced, and any United States personnel who employ torture or cruel, inhuman, or degrading treatment or punishment concerning a detainee would be violating the law. You also asked about the status of the Law Enforcement Torture Prevention Act. As we have previously noted, the Convention does not require state parties to enact a crime specifically labeled torture, but rather to ensure that the underlying conduct encompassing torture is criminalized. Under United States law, that conduct is prohibited by various statutes. For example, torture may be encompassed by statutes prohibiting torture under that term, as in the prosecution of Chucky Taylor, which we described yesterday. Or it may be encompassed by statutes prohibiting, for example, the violation of civil rights. As one example, in 2006, 4 correctional officers at the Federal Bureau of Prisons participated in the abuse of an inmate who was thrown to the floor and restrained while one of the officers repeatedly stomped on his back and shoulders. 4 officers were prosecuted and convicted in federal court for violating the inmate's civil rights and sentenced to prison. Because we believe the relevant conduct is already covered, the administration is not actively considering adopting new federal legislation prohibiting torture within the United States. Mr. Bruni, you also asked whether, although U.S. law prohibits the commission of torture by United States nationals everywhere in the world, an American official could escape liability by effectively delegating the commission of torture to officials of a foreign government. The answer to that question is no. Just as federal law prohibits actions taken by United States officials personally, so would it apply to actions directed or willfully caused by those officials, even if those actions were actually carried out by others. You also requested examples of public officials prosecuted for offenses that would constitute cruel, inhuman, or degrading treatment or punishment, as prohibited in the Detainee Treatment Act of 2005. Following are 2 examples from the civilian justice system of prosecutions under federal criminal law, and my colleague General Gross has already discussed actions taken by the military justice system. In June 2003, David Pissarro, a CIA contractor stationed at a United States Army base in Afghanistan, participated in taking an Afghan man named Abdul Wali into custody and detaining him at the base. Pissarro then interrogated Wali in connection with rocket attacks on the base and brutally beat him, after which Wali died. The CIA Inspector General referred the case for prosecution. Pissarro was then indicted by the Department of Justice for committing assault. In August 2006, he was convicted following a jury trial. In November 2008, Don Ayala, a Department of Defense contractor in Afghanistan, participated in capturing and detaining an Afghan civilian named Abdul Salam. Salam had doused another American contractor, Ms. Paula Lloyd, with a flammable liquid and set her on fire, causing her death. After learning what happened to Ms. Lloyd, Ayala approached Salam, who was still being detained, and shot him to death. In February 2009, Ayala was convicted in federal court of manslaughter. Both Mr. Modvig and the chairperson asked for further information regarding Mr. Durham's review regarding detainees alleged to have been mistreated while in U.S. custody subsequent to the September 11th attacks. Mr. Durham and his team reviewed the treatment of 101 such detainee cases. In so doing, he drew upon information provided by the CIA Inspector General, a report from the International Committee of the Red Cross regarding the treatment of high-value detainees formerly in CIA custody, the Department of Justice's report on legal guidance related to enhanced interrogation techniques, and other sources. After reviewing a substantial volume of information, Mr. Durham recommended the opening of 2 full criminal investigations, and Attorney General Holder accepted that recommendation. After investigation, the Department ultimately determined not to initiate prosecution of those cases. That decision was made based on the same principles that federal prosecutors apply in all determinations of whether to initiate a prosecution. Specifically, Mr. Durham's review concluded that the admissible evidence would not be sufficient to obtain and sustain convictions beyond a reasonable doubt. Because the cases did not result in prosecutions, I cannot publicly describe with specificity the investigative methods employed by Mr. Durham or the identities of any witnesses his team may have interviewed. Overall, however, the investigations involved interviews of approximately 96 witnesses and the examination of physical and documentary evidence. In short, Mr. Durham had access to and reviewed a broad array of information relating to allegations of mistreatment. In addition, prior to Mr. Durham's review, career prosecutors at the Department of Justice reviewed certain cases involving alleged detainee abuse. These reviews led to charges in several cases, including the 2 cases I previously discussed. The Department determined not to initiate federal prosecution in other cases for reasons consistent with the same principles of federal prosecution that I discussed before. With respect to individuals who provided legal advice regarding the permissibility of enhanced interrogation techniques, a 2010 review conducted by a senior career Department of Justice official concluded that 2 senior Justice Department lawyers who gave advice in 2002 and 2003 regarding the application of the torture statute and the use of specific interrogation techniques had made errors and had exercised poor judgment, but that they had not intentionally or recklessly provided incorrect advice or acted in bad faith. Mr. Modvig, you also requested an update into the investigation by Mr. Durham of the destruction by CIA personnel of videotapes of detainee interrogations. In November 2010, the Department announced that after an exhaustive investigation into the matter, Mr. Durham had concluded that he would not pursue criminal charges. The committee asked a number of questions regarding conditions of confinement in prison, including the use of restricted housing. As the committee is aware, the vast majority of imprisoned persons in the United States are held in state facilities. My colleagues will therefore address some of these questions. I will address questions that particularly regard federal facilities. Mr. Bruni, you asked about the psychological effects of the use of restricted housing on prisoners. We thank you for allowing us the opportunity to clarify and express to the committee that restrictions on prisoner housing in the United States are not taken for the purpose of inflicting psychological harm, but rather to ensure the security of the prison environment. We are, however, committed to preventing any abuses with regard to detention conditions and to ensuring the safety of vulnerable inmates. The Bureau of Prisons has undertaken a comprehensive and independent assessment of the use of restricted housing in the federal system and is looking forward to sharing further information on this subject once the study is released in the coming months. Mr. Bruni, you asked whether it could constitute mental torture for prisoners to spend a period of years between being sentenced to death and having that sentence carried out due to their pursuit of appeals or other procedural mechanisms to challenge their convictions or sentences. Although we cannot comment on any particular pending litigation, we do not believe as a general matter that delays that result from a convicted prisoner's decision to take advantage of the heightened procedural safeguards mandated by the Constitution and laws of the United States constitute a form of mental torture. Mr. Chairperson, in response to your question, the President has directed the Department of Justice to conduct a review of how the death penalty is applied in the United States. The Department is taking a look at this. We have no additional update at this time. Finally, Mr. Bruni, you asked about efforts to reduce the federal prison population. These efforts have been a priority for the Attorney General and have taken a number of different forms, many of which are reflective of the recommendations in the congressional report that you cited. For example, as part of the Smart on Crime initiative announced last year, the Department has modified its charging policies to ensure that mandatory minimum sentences are reserved for the most serious criminals. In 2014, with the support of the Department, the United States Sentencing Commission adopted amendments to lower guideline penalties for all drug offenders. In addition, the Department is pursuing alternatives to incarceration for low-level, nonviolent crimes, including the use of diversion programs that do not require incarceration. Just 2 weeks ago, in fact, the Attorney General visited one such program at the federal courthouse in Brooklyn, New York. In September 2014, the Attorney General announced that the federal prison population had dropped by approximately 4,800 inmates in the past year. This is the first time the federal inmate population has fallen over the course of a 12-month period since 1980. I will now turn to my colleague Jennifer Dinas from the Department of Justice Civil Rights Division.
Mr. Chairperson and distinguished members of the committee, my name is Jennifer Dinas, and I'm an acting senior counsel in the Justice Department Civil Rights Division. The Civil Rights Division works to uphold the civil and constitutional rights of all who live in the United States. Mr. Modvig, you asked about the federal government's response to recent events in Ferguson, Missouri. The Department of Justice is working across the nation to ensure that the criminal justice system is fair, constitutional, and free of bias. Among the federal government's efforts in Ferguson, Missouri are an ongoing and active criminal investigation into the fatal shooting of Michael Brown, which is separate from the local investigation and is looking at whether there were federal civil rights violations. There is also an active and ongoing civil investigation into the Ferguson Police Department that is focused on 4 key areas: the Ferguson Police Department's use of force, including deadly force, stops, searches, and arrests, discriminatory policing, and treatment of detainees inside Ferguson City Jail by Ferguson police officers. The Justice Department's Community-Oriented Policing Services Office, often called COPS, has launched a voluntary collaborative reform initiative with the St. Louis County Police Department, which will include an open, independent, and objective assessment of key operational areas of the police department. The findings and any recommendations will be provided in a public report. Additionally, the police department requested that COPS conduct an after-action report on the police department's response to the protests following Mr. Brown's shooting. That investigation is underway. Finally, President Obama ordered the U.S. government to review federal programs that provide military equipment to local jurisdictions, including whether and which such material should be provided to local law enforcement, whether local police units are receiving proper treatment for the equipment they receive, and whether that equipment is being effectively tracked. Ms. Belmere, in response to your question about for an update on the Chicago Police Department and John Burge, several individuals who were convicted after allegedly being subjected to improper tactics by the Chicago Police Department were ultimately exonerated of the underlying crimes. However, a federal civil rights investigation did not develop sufficient evidence to prove beyond a reasonable doubt that prosecutable constitutional violations occurred. Ms. Belmere and Mr. Gaye, you asked about the use of tasers. The Civil Rights Division recognizes that the vast majority of law enforcement officers work tirelessly to protect the rights of the communities they serve. But when officers commit unconstitutional violations or violate individuals' rights under federal law, the division can and does prosecute individual officers criminally and has successfully prosecuted many cases involving tasers. In a recent case, the division obtained a guilty plea from a Pennsylvania police officer in 2013 for an assault against a victim involving the use of a taser, all while the victim was handcuffed and not posing a threat. And in the civil context, the division intervened in a civil action alleging excessive force through the inappropriate use of tasers by the Franklin County Sheriff's Office in Columbus, Ohio, which resulted in a court-enforceable agreement. I will address a number of questions regarding prison conditions. Mr. Bruni and Mr. Modvig, you both asked about extreme heat in prisons, including in Louisiana and Texas. The Civil Rights Division has authority under the Civil Rights of Institutionalized Persons Act to investigate and remedy unconstitutional conditions of confinement imposed by state and local governments, pursuant to a pattern or practice of civil rights violations. The Department of Justice filed a statement of interest in a civil case by inmates challenging the constitutionality of extreme heat conditions at the Louisiana State Penitentiary at Angola. The court issued an order in favor of the plaintiffs and the case was appealed. The Justice Department filed an amicus brief in support of the plaintiffs, arguing that the district court's findings under an Eighth Amendment violation and the corresponding injunctive relief were properly made and entered. The department also received information about extreme heat conditions in Texas prisons from the University of Texas Human Rights Clinic earlier this year, but we are unable to comment on the pending litigation in Texas or the merits of those cases. Mr. Chairperson and Mr. Modvig, you asked about juveniles. The Justice Department is committing to protecting the rights of youth in juvenile detention and commitment systems. We often obtain relief that is designed to reform juvenile detention systems and that affects large numbers of juveniles. For example, we have agreements concerning 7 facilities for juveniles in Puerto Rico, 7 juvenile facilities in Ohio, and 14 facilities in Los Angeles County, California. Mr. Modvik, in response to your request for statistics, according to the Department's Bureau of Justice Statistics, approximately 7,400 youth ages 16 through 17 were in adult prisons and jails in 2011. And in 2011 through 2012, an estimated 4.7% of these youth in prisons and jails experienced sexual victimization. Rates of sexual victimization were higher in state juvenile facilities and state contract facilities. In 2012, an estimated 9.5% of all adjudicated youth held in state or privately run facilities experienced sexual victimization. Excluding youth held in locally or privately operated facilities, the rate of sexual victimization declined from 12.6% in 2008 through 2009 to 9.9% in 2012. This is largely due to a drop in reported staff sexual misconduct. With regard to the question about life sentences for juveniles, the U.S. Supreme Court has held that sentences of life without parole violate the Eighth Amendment's prohibition on cruel and unusual punishment when applied to juvenile offenders for non-homicide crimes committed as a juvenile and cannot be made mandatory for juvenile offenders, even those who have committed murder. We are working with members of Congress to refine legislation drafted to address the Supreme Court's decisions on these issues. Mr. Bruni, Mr. Taguchi, and Mr. Modvik, you also asked about solitary confinement. The U.S. Constitution prohibits the use of seclusion in a manner that constitutes cruel and unusual punishment. The Civil Rights Division currently has matters involving allegations of misuse of solitary confinement in 20 states and U.S. territories, and has issued findings or reached settlements in some of those matters. For example, in May of 2014, the Division reached an agreement with the State of Ohio and private plaintiffs which will dramatically reduce and eventually eliminate its use of seclusion on young people in its custody. The agreement also ensures youth in juvenile facilities will receive individualized mental health treatment to prevent and address the conditions and behaviors that led to the seclusion. Mr. Bruni, you asked about sexual violence in detention. The United States is taking extensive action to prevent sexual violence in its detention centers. As you know, the Prison Rape Elimination Act, or PREA, aims to prevent, detect, and respond to sexual abuse in confinement facilities at the federal, state, and local levels. States that do not comply with the Justice Department standards issued under PREA face certain reductions in their Justice Department funding. The Civil Rights Division has conducted 3 civil pattern of practice investigations that focus exclusively on the sexual abuse of prisoners. And as an example of the Division's work in the criminal realm, earlier this month, a former captain at a detention center in Albuquerque, New Mexico, pleaded guilty to federal charges related to sexual assaults of women inmates in his custody. This is but a sample of the Civil Rights Division's work. I will now turn to Director Wall of Rhode Island to address a number of your questions from the state perspective. Thank you.
Mr. Chairperson and distinguished members of the committee, my name is A.T. Wall. I am Director of the Department of Corrections for the state of Rhode Island, one of the 50 states that together comprise the United States of America. I serve as the Chief Executive Officer of an agency that is responsible for Rhode Island's adult correctional operations, including both jails and prisons. I joined the profession 38 years ago at the line level, and I've dedicated my career to the compelling challenges of our field. We in corrections know that we hold great power over those who are subject to our authority. We have a corresponding duty to exercise it fairly, thoughtfully, humanely, and with respect for their human rights. State correctional systems accomplish our mission within the overall framework of federalism, whereby authority is allocated between the national government and the states. Federal and state laws function together in a manner consistent with the provisions of the United States Constitution. I'm honored to appear before this committee and to respond to the questions that you have raised. Mr. Chairperson, Mr. Modvig, and Ms. Pradhan Mala, in response to your questions about solitary confinement, recent efforts to achieve reforms in this area have addressed the process of determining whether to place someone in such a status. the degree of isolation, the condition under which the inmate lives in this setting, the opportunities to earn removal from the status, and ways to reintegrate into the general population. My perspective, of course, is that of our state. In Rhode Island, we make efforts to ensure that inmates in administrative segregation are in fact not completely isolated. For instance, they have non-contact visits, the ability to communicate with inmates in neighboring cells, outside exercise 3 days per week for 1 hour minimum, access to education and reading materials, radios, mail privileges, legal assistance, meetings with staff upon request, out-of-cell access to clergy, and monthly telephone calls to family. Above and beyond, in some states, individual case reviews have been taking place of everybody in this status and have led to significant declines in the use of supermax cells without compromising safety and security. Mr. Bruni and Mr. Modvig, in response to your questions about the Prison Rape Elimination Act, sexual assault, and LGBTI issues in prisons. We correctional officials are developing policies and practices to comply with the Prison Rape Elimination Act standards in order to protect inmates against sexual coercion by staff or other inmates. It bears noting that staff sexual misconduct with inmates is a crime in every single state. Consent is not a defense. PREA mandates independent audits to determine compliance, and that process has already begun. The audits cover a wide variety of subjects, including training of staff, background checks, education of inmates about their rights, investigative protocols, individualized assessments of risk for victimization or predatory behavior, responses from medical and mental health personnel, cooperation with law enforcement authorities on criminal charges and victim services. They are comprehensive. Rhode Island is among the overwhelming majority of the states that are working to actively meet those standards. The standards include a focus on the vulnerability of LGBTI offenders to sexual abuse. States have adopted practices designed to respect the dignity of these persons, make individualized housing and program placement for them, and protect them from harassment and victimization. It is done through specialized training for custody and clinical staff and many other ways as well. Mr. Bruni, in response to your questions about overcrowding, advocates and the Department of Justice have filed numerous lawsuits targeting overcrowding as a violation of the Eighth Amendment's prohibition on cruel and unusual punishment. They have resulted in expansion of bed space and mandatory releases in a number of states. More recently, a number of states have taken the initiative to use a new model. This approach, known as justice reinvestment, involves the use of outside experts to conduct comprehensive analyses of the factors that drive overcrowding in a particular state. They then develop a set of options for that state to reduce prison populations, and the savings are reinvested in programs that contribute to public safety. Justice reinvestment is proving effective in a growing number of states, including my own, across the country. In response to questions about the shackling of pregnant women, state correctional systems are focusing on statutes and policies that improve the protocols for the treatment of women in detention during labor and delivery. 19 states, including Rhode Island, have enacted statutes restricting and the shackling of pregnant inmates, and legislation is under consideration elsewhere. I now turn the floor over to my colleague, Jim Hood, Attorney General for the state of Mississippi.
Good afternoon, Mr. Chairperson, members of the Distinguished Committee. My name is Jim Hood. I'm the Attorney General of the state of Mississippi. I'm finishing my third term in that capacity. It's an honor to be here before you today. As you might tell, I speak a little bit different than my colleagues here on the panel. I'm from the southern United States, and I hope the interpreter doesn't need an interpreter to understand my remarks. I am the president of the National Association of Attorneys General this year, and I don't speak on their behalf. I would like to address a few questions that were raised earlier. Mr. Modvick, you raised a question about training and use of force. As Attorney General, our office is responsible for training state and county and municipal law enforcement. I know many big countries, Denmark may, but I think have a state capacity. But in the United States, we have completely separate system, a judicial system, state prosecutors, and we prosecute most of the cases, criminal cases. So in our system, we have extra protections. The United States Constitution provides the floor. The states can provide more rights, and in some cases, some do. In some cases, the states violate the floor, and the federal Constitution and the federal courts are the backstop for our actions. But in the training capacity that we do in most local law enforcement officers as to the use of force, they're all trained when they go to the academy. In most instances, they're trained annually as to the use of force. Most law enforcement agencies actually have a written policy on use of force. I know you can go online. Chicago, for example, has these use of force policies online. Mr. Modvick, Mr. Gaye, and Ms. Belmer asked about training and the use of tasers. Most agencies, they train annually. The officers all have to experience being tased. There's a Taser International is a company that provides some guidance and a lot of training that's available. So for liability purposes, they are active in the training area of local law enforcement and how to use the taser. Chicago, for example, Ms. Belmer, you were asking about Chicago officers' use of tasers. There's an actual website where they have their policies and how the proper use of tasers, and that's at directives.chicagopolice.org. So there are those mechanisms in place and written policies. The last issue that I would like to address deals with interrogation and reporting of abuses. I was a district attorney. I tried cases. I was served 2 terms, tried about 100 jury trials, and I directed law enforcement in my 7-county area as to what type of interrogations they should do. I required in most instances a video of interrogation so that we knew what was asked and how the suspect was treated. Some instances they didn't have that capability. We would do audio of any statements that were given by a defendant in a custodial interrogation context. I found that law enforcement officers in my 25 years as a prosecutor actually want to do the right thing. They want to be trained properly so that they aren't embarrassed in court. They don't want their evidence thrown out because they didn't provide the proper instructions to a defendant. And they want to try to do the right thing, and they have a duty to learn to do it the right way. They usually do that, but in instances where they don't, where they violate someone's constitutional rights, then there's a backstop. There's federal court, and they might be sued under Section 42 U.S.C. 1983. That's where in federal court you can sue someone. They can also be sued in state court, and lastly, they can be prosecuted criminally in the federal court system or in the state system by abuse of a person in custody. They have a duty to report any type of abuses during interrogations to their superiors, or they are subject to losing their job. I now turn this over to Nader Baruch, the Department of Homeland Security. Thank you.
Good afternoon. Mr. Chairperson and distinguished committee members, on behalf of the United States Department of Homeland Security, or DHS, I welcome the opportunity to participate in today's presentation. I am Nader Baruch, the Associate General Counsel for Immigration at DHS. My department houses most of the government agencies involved in the U.S. immigration system, including the Immigration and Customs and Border Protection, which I'll refer to as CBP, whose mission it is for border management and control, U.S. Immigration and Customs Enforcement, or ICE, which I'll refer to as ICE, whose primary mission is to promote homeland security and public safety through the criminal and civil enforcement